Welcome to another episode of Tricks of the Trademark with me, Eric Pelton. Here, I share insights, tips, and advice based on my 25 years of experience helping businesses protect and build bold brands. The following are the comments that our law firm recently submitted regarding the USPTO's proposed trademark fee changes and increases. This was in response to the Notice of Proposed Rulemaking published in March of 2024 in the Federal Register. You can find much more detail online on my website. Since 1999, our firm has represented thousands of clients in the USPTO trademark prosecution, maintenance, and litigation. Our clients have received more than 4,000 U.S. trademark registrations and have been involved in dozens of disputes before the TTAB. In addition to representing myriad small business trademark owners, our firm itself is a small business and the owner of more than a dozen U.S. trademark registrations. In general, we do not oppose across-the-board fee increases to match the growth in expenses. We understand and support the need to increase fees to cover rising costs, align fees with internal costs, and provide financial security for the agency. However, we are concerned that the rulemaking's impact on small businesses will be significant. Small businesses make up a large portion of the American economy. Moreover, according to a 2013 report from WIPO, small and medium-sized enterprises rely more heavily on trademarks than patents. Unfortunately, small businesses typically do not have associations, in-house attorneys, or the other kinds of resources necessary to comment on proposals like these. The rulemaking contains several new features that increase the complexity and unpredictability of filing and prosecuting a trademark application. These changes are likely to adversely impact those without experienced counsel. The Lanham Act directs the USPTO to register trademarks unless one of a limited number of prohibitions applies. To quote, "No trademark by which the goods of the applicant may be distinguished from the goods of others shall be refused registration on the principal register on account of its nature unless it, so on, meets one of the following requirements." In other words, the Lanham Act creates a structure whereby trademark applications are presumed to be registrable but for one of the statutory prohibitions. We believe the rulemaking will create new procedural hurdles for applications that impede their presumed registrability, resulting in fewer applications being filed, approved, and registered. In our assessment, a better alternative would be to distribute the costs of processing applications evenly across all applicants. A standard application fee for all would be more predictable and fairer. It would be without any penalty for the type of identification of goods or services used, without any penalty for the number of characters used in the identification, and without any penalty for nuanced requirements such as the domicile address, color claim, or translation. For example, a filing fee of $400 per class for all applications without any possible additional penalties or surcharges would treat all applicants equally. Such a fee would cover the historical cost, $373 according to the USPTO's materials, and allow some padding for inflation and additional cost increases. The rulemaking creates new procedures and penalizes imperfect applications by imposing additional costs, upending the established practices of the USPTO and trademark applicants. We believe that it would be prudent for the USPTO to ensure that the trademark application fee structure provides an incentive for small businesses to protect their trademarks. We are concerned that the fee increases and changes will add to the burdens for small businesses who are seeking to obtain trademark protections. The investment in trademark clearance and registration for a small business is even more significant and valuable. It helps guard them against the risks and expenses of trademark disputes and litigation. The rulemaking, however, is likely to produce the opposite outcome, limiting small businesses' access to the benefits of trademark registration, which in turn could allow for even more overreaching enforcement efforts from big businesses. Now we have some specific comments regarding some specific elements of the proposed rulemaking. For example, we have concerns regarding the new fee for using a free-form description of goods or services, rather than choosing from the pre-approved options in the ID manual. Many goods or services are described well in the ID manual, but sometimes the ID manual entries are too detailed and specific. Sometimes they do not appropriately describe an applicant's goods or services, and other times they feature more specification than is required to serve as a sufficiently definite identification. Pro se applicants may choose inaccurate descriptions or descriptions for which specimens of use are not really available. We are also concerned that requests to update the ID manual may not be responded to in a timely fashion, given that such requests will inevitably increase. Finally, the rulemaking sets the cost for choosing a free-form identification at $200 per class, which increases the application filing fee by more than 50%. Such an increase outpaces the additional examination burdens. A free-form identification fee of $50 or $100 would be far more reasonable while still incentivizing applicants to use the ID manual. The rulemaking features a new fee of $100 per class if an applicant fails to provide sufficient information across any one of 20 categories. The proposed penalization adds another layer of complexity to an already very intricate application process, along with the potential for additional costs. Again, this leads to increased unpredictability for applicants and their counsel. Notably, many of the requirements for a base application are not affected by the number of classes in application. For example, an applicant's name, domicile, address, legal entity, citizenship, color statement, and marked description are uniform across all classes in an application and require the same time and attention irrespective of class count. We propose that the USPTO reconsider whether the fee imposed for such information deficiencies should be per class or, more reasonably, per application. The rulemaking does little to detail or justify the overall financial needs of the USPTO, including the increased IT costs. At the end of fiscal year 2022, the USPTO's trademark operating reserve was approximately $209 million, which is considerably above the minimum operating reserve of $120 million. Surprisingly, despite significant projected rent savings, the TPAC fiscal year 2023 annual report issued last fall forecasted a trademark operating reserve of just $92 million at the end of FY 2026. This means that the USPTO trademark operation is operating at a loss and at a real risk of dipping below the minimum level of reserves within 2.5 years. According to the USPTO's material, this is due in part to a historically low rate of post-registration filings. Not discussed, however, is the impact of IT expenditures and delays on the budget. Importantly, the USPTO's forecasting presumes that the proposed fee increases and newly created fees will not lead to any decline in the number of new applications being filed. However, such an assumption may prove incorrect. We understand that the USPTO needs to ensure proper funding and that filing levels have dropped from the recent all-time highs. But details on where and when the USPTO trademark operation spends its money have been largely absent from the published materials. There's been no public discussion of alternatives that might assist in balancing the budget while filings are lower, such as cuts to some spending, reducing overtime, employee buyouts, or a hiring freeze. IT improvements are certainly valuable and needed, but the general public and users of the USPTO systems are entitled to know more about what specific improvements are scheduled and upcoming and why the costs and delays have escalated over previous projections. For example, no details were provided to the public about the cost of the new trademark search system or how long the USPTO was aware of the need to retire TESS, the old system, by a certain date. A March 2019 report from the Office of Inspector General of the U.S. Department of Commerce titled, quote, USPTO needs to improve management over the implementation of the Trademark Next Generation system, end quote, noted the tremendous delays and cost overruns in trademark IT expenditures at that time. In the 5 years since that report, we believe the USPTO has not sufficiently discussed and addressed in public forums the concerns the report raised. Because the primary effect of the rulemaking is to generate more revenue and fees for the USPTO, we believe the USPTO is obligated to more openly discuss how it spends its funds. Finally, if the USPTO's investments in IT enhancements and updates over the last few years come to fruition soon, they should lead to considerable savings of time and thus expenses in processing trademark applications. We encourage greater discussions with and feedback from users about how IT improvements and software tools could potentially reduce USPTO costs and examiner hours. The proposed fee increases and procedural hurdles created by the rulemaking are inconsistent with the office's goal of increasing access to IP protections for individuals and businesses that are part of underserved and disadvantaged communities. We applaud the USPTO's efforts to narrow the gender gap and to support inventors and rights holders from minority communities. But across-the-board trademark fee increases, combined with the increased complexity in predicting the total cost of the applications, could very well set back those efforts. We implore the USPTO, at a minimum, to search for ways to conduct greater outreach to populations historically underserved by intellectual property rights. In our opinion, the interests of equity would minimize fee increases for new trademark applications and prevent the newly created fees and the unpredictability that they will bring. We also suggest that the USPTO consider exploring reduced trademark application fees for small businesses and for first-time applicants to promote trademark protection in communities that have been disadvantaged over the years. To conclude, trademark fee increases are understandable as costs rise. However, we implore the USPTO to work to minimize the impact of the increases on small businesses. The rulemaking features increased application fees and complexities that will no doubt adversely affect small businesses and thus could easily impact the entire trademark register and the American economy. Additionally, the public is entitled to greater transparency regarding the fee increase justifications, including the USPTO's expenditures on IT upgrades. Now, I want to thank you for sticking with me for this long but important piece, and stay tuned for the next video to learn more about the USPTO's proposal. You've just listened to another episode of Tricks of the Trademark with me, Eric Pelton. For lots more episodes, videos, content, links, blog posts, and more, visit our website at www.ericpelton.com.